Now that you have determined the valid reasons for terminating your employee, you now need to prepare for the most challenging aspect of the process, the termination interview. Let's get started. The decision to terminate an employee can be both emotional and frustrating. If not handled properly, it can also result in expensive litigation. Following the proper protocol in conducting the termination softens the blow to the terminated employee, who is very often surprised that they are being terminated, protects the business from potential litigation arising from the termination, and reassures the owner or manager that they did the right thing. In this unit, we will consider the risks and how you can effectively manage the termination process. Firing an employee is rarely pleasant. However, a properly conducted termination meeting, which preserves the employee's dignity, can help diffuse even the tensest of situations. There are several steps you can take to fulfill your legal obligations to terminated employees, and avoid escalating any hostilities over the firing. Here are some steps to follow. Once an employer has made the decision to terminate an employee, whatever the reason, breaking the news is likely to be at the very least awkward. Make sure you have done the groundwork needed to document and justify your actions. Then you can use the following time-tested advice on how to conduct the actual termination meeting, to do what you have to do, minimize your own discomfort, and make things as easy as possible on the departing employee. It is really important to preserve the employee's dignity. We can't say it strongly enough. Even when firing a worker, you should make every possible attempt to maintain the employee's dignity. It's natural for a person being fired to feel resentment towards you and your business. So, everything you do in a termination meeting should be designed to minimize, as much as possible, this natural resentment. We say that not so much out of concern for the worker who is being discharged, but for your own self-protection. It's not good for your business reputation to have ex-employees bad-mouthing you all over town. If customers think that you treat your employees unfairly, they might think that you'll do the same to them. Bad feelings can bring about bad consequences. You'll also want to avoid, as much as you can, the possibility that you might be sued by a disgruntled ex-employee. Finally, in the worst-case scenario, there have been times when fired employees become so distraught that they threaten to harm their former boss, co-workers or the business. Treating workers as humanely as possible will minimize the chance that this might happen to you. Who should conduct the meeting? In most cases, the immediate supervisor of the worker should be responsible, because he or she is usually most familiar with the reasons for the discharge. Also, the supervisor will usually be most familiar with the worker's personality, and will be most able to handle him or her in the face of bad news. If you are not the immediate supervisor, let him or her handle the meeting. Besides the supervisor and the worker who's being fired, there are situations where you may want to have a third party attend the meeting. If the person being terminated requests a witness, it's probably best that you allow this, so that the person doesn't feel that he or she is being railroaded out the door unfairly. But do explain that the person is there as an observer only, not to act as a representative or argue on behalf of the worker. You'll want to conduct the meeting out of sight and earshot of any other employees, in a quiet place where you won't be interrupted. The meeting room should be in a location that does not alert other people as to what is taking place. Many advisors say that meetings should be held on neutral ground, not in your office, and not in the departing worker's office or workplace. Early in the day and early in the week is generally considered the best time to hold a termination interview. Avoid Fridays and the day before a holiday or vacation. An employee who is let go on a Friday has 2 days to brood about his or her treatment by the company and to look for ways to retaliate. On the other hand, discharging a person early in the week provides him or her with an opportunity to focus on the future and begin looking for a new job right away. Early in the day and early in the week is generally considered the best time to hold a termination interview. Avoid Fridays and the day before a holiday or vacation. An employee who is let go on a Friday has 2 days to brood about his or her treatment by the company and to look for ways to retaliate. On the other hand, discharging a person early in the week provides him or her with an opportunity to focus on the future and begin looking for a new job right away. The actual termination meeting should last about 10 to 15 minutes and have the sole purpose of providing a simple and concise statement of the decision to terminate the employment relationship. Have phone numbers ready for medical or security emergencies. Prepare what you will say ahead of time. It's a good idea to write it out, and have a checklist in front of you, so that you don't get sidetracked and forget any important points. Consider including the following in your termination meeting. First, give an adequate reason for the discharge. Many workers who sue their ex-employers do so because, at heart, what they really want is a full explanation of why they were let go, and a chance to give their side of the story. You don't have to spend a lot of time going over every last detail of the employee's conduct that led to the discharge, but you should provide a reasonable explanation. The next step is to seek out the employee's explanation or interpretation of events. You may already have done this when you investigated any misconduct that led to the firing. Even so, you should allow the employee to have his or her say, and even to vent a little emotion. Don't interrupt or talk over the person. If the employee feels that he or she was forced out because of discrimination, harassment, or some other allegedly offensive or illegal conduct on your part, you'll want to know about it now so that you can alert your attorney. Next, make it clear that the decision is final. If you take the position that the decision has already been made, all alternatives have been considered, and all the other managers or owners are in agreement, and that you are merely giving this information to the worker, you'll find it easier to keep your cool and keep control of the situation. Next, you should briefly cover the vacation pay, separation pay, continuation of health insurance or life insurance benefits, etc., that you are offering. If you are attempting to get a release from the employee, now's the time to present it. It's a good idea to have the employee's final paycheck ready, so that he or she has something positive to carry away from the meeting. The next step is to explain your job reference policy. If it is your policy to provide only job title, dates of employment, and salary history, now is the time to say so. If you normally give more information, when it is requested in writing by a qualified person, like a prospective employer, tell the employee. In some states you may be required to provide a service letter on request. In some cases, you may be willing to provide a satisfactory job reference, or to tell prospective employers that the worker resigned voluntarily, if the employee is willing to sign a release form. In Step 6, collect what's yours from the employee. You'll need to collect any keys, cell phones, company car, company credit cards, or any other property belonging to you from the employee. You may want to do this now, or you may want to let the employee save face by allowing him or her to return these items to you at a specific later date. Finally, as a caveat, if the employee was working on an important project, or has any important files, records, or property belonging to a customer in his or her possession, you'll want to make arrangements to get these back. We suggest that you make it clear that the payment of any severance pay, or other benefits after discharge, depends on the employee's cooperation with you in this area. Written records are also crucial in disciplinary and grievance matters. Employers should keep a written record of any disciplinary or grievance case that they deal with. There should be records of the various stages of the procedure, including of the complaint, the employee's defense, findings made, actions taken and reasons for them, whether there was an appeal and its outcome, any grievances raised during the procedure, any subsequent developments, and notes of any formal meetings. Given that disciplinary action, especially if it leads to a dismissal, can lead to a tribunal situation, it's vital that employers can produce a proper paper trail that establishes the validity of their disciplinary procedures. Part of this is being able to demonstrate that an employee has been treated fairly, and in a way that's consistent with the treatment of other employees, in comparable situations. Copies of meeting records should be given to the employee, including copies of any formal minutes that may have been taken. In some circumstances, such as to protect a witness, the employer might be justified in withholding some information. Employers must keep personnel records, in accordance with the rules set out in the Data Protection Act. Such records are confidential, but individuals concerned have the right to request and have access to certain personal data. The termination interview must be managed well. We cannot overemphasize the importance of preparing carefully for any termination meeting, and ensuring that you have covered all the possible legal risks and issues before you enter a termination meeting. Finally, it is important that all employees are treated fairly and equitably, and with dignity. Subscribe now and join us in your career journey. Want to learn more? Click on one of our websites to view our range of online business and management courses.